So I want to welcome all of you to an inaugural lecture tonight. My name is Ian Jandrell. I'm a Deputy Vice Chancellor, but I also have the privilege of having an association with the Faculty of Commerce, Law and Management, and therefore I'm your host for tonight. Now, I must also tell you that my background is in electrical engineering, so as long as our inaugurating lecturer speaks slowly and loudly, I should also enjoy the evening. But the other reason that I think they put me here is because there's load shedding, and that happens tonight at 6 o'clock. So if the lights will go out at 6 o'clock, they'll probably come on quite quickly. But if you get nervous, hold on to somebody close to you or satisfy yourself with something to entertain you until everything's working again. I'm afraid this is the reality we live in. But I think what is significant is all of our lecturers are given this test to understand how they get through moments of darkness and moments when the IT system falls over, but we have to get through it. So my role tonight is very, very simple. Apart from welcoming you, it's to introduce to you the folk in the procession. We have, of course, on my right, the Acting Dean of the Faculty of Commerce, Law and Management, Professor Jason Cohen. Next to him, the Head of the School of Law, Professor Engela Schlemmer. We have the Dr. Makanatsa Makonesi, who will be delivering the vote of thanks, and she will be introduced to you later on. And of course, our star of this evening, Professor Tumai Murombo, who is going to profess tonight. And our responsibility is simply to check that he can indeed profess. But I want to say this, and I'm looking at this audience and recognizing that there are also a lot of people joining us online. I think it is so nice that this evening we're able to be here together to support our colleague, friends and family here with him to support him and listen to him deliver his inaugural lecture. You know, it was just a few months ago when we wouldn't have been able to do this. And we were in, can I say, the sterile environment of 2 dimensions and online. But here we can see each other, we can read the body language, and we can enjoy each other's company. So without any further ado, I'm going to ask the Dean of the faculty, Professor Jason Cohen, to introduce our inaugurating lecturer. Professor Cohen.
Good evening, everyone. As our DVC said, my name is Jason Cohen. I'm the Acting Dean of the Faculty of Commerce, Law and Management. It's my pleasure to welcome you all here this evening, colleagues, family, friends, our DVC, Professor Jandrell, Head of School, Professor Schlemmer, Dr. Mukanese, hi, but of course, very special welcome to Professor Tumai Murombo himself. After all, this evening is about you. As Professor Jandrell mentioned, it's a special moment for Tumai, celebrating his academic achievement, his elevation to the position of full professor, and along with that, his induction into the Academy and the Senate. And we're very much looking forward to the presentation that you'll give this evening. I recall Tumai as a member of many of our staffing selection and promotion committee processes, and he always used to press applicants. He always used to say, what makes you a professor? What do you profess? And so we're very much looking forward to this evening's presentation from this professor and a chance to share your knowledge, present your lecture to both the specialist and non-specialist audience. So by way of introduction, Tumai has an LLB with honors from the University of Zimbabwe, an LLM in environmental law from Pace University in New York, an LLM in human rights law from UCT, and a PhD from WITS. Tumai joined WITS University in 2006 as a lecturer, and he is now Professor of Law in the School of Law and was also former director of the Mandela Institute at WITS. He's an admitted legal practitioner, notary public, and conveyancer. Professor Murombo is an expert in environmental law, water law and governance, energy and climate change, sustainability, the extractives industry, and the environment, among others. As an NRF-rated researcher, he has taught, researched, advised governments and civil society organizations on these areas in Southern Africa. He has extensively worked with public interest environmental organizations and nurtured many environmental lawyers in the region. Professor Murombo co-founded and is board of the Zimbabwe Environmental Law Association. He sits on the advisory board of the Copper Mark, the editorial board of the Journal of African Law, and is a member of the Water Tribunal South Africa, the Environmental Law Association South Africa, the IUCN World Commission on Environmental Law, its Environmental Law Academy, and the Working Group on Climate Change and Energy. It's my pleasure, Professor Murombo, to invite you now for your inaugural lecture on the topic of transforming water resource governance framework in South Africa using an untransformed law, the Courts and the National Water Act of 1998. Professor Murombo, the podium is yours.
Good evening. Please do not take a photograph of this. Thank you. So I'm starting my inaugural lecture without my family. As you would imagine, the topic of my talk is about water, law, and governance. And as the heavens would have it, it rained today. A blessing, but also a very disruptive event in Johannesburg, where traffic can become very hectic on a Wednesday, and schools are open, and everyone is moving from their own board and dressing up, and yeah. If my children were here, I was going to start the protocols by observing them. But I will do that once they are here. For now, I did see another child of mine who can serve the same purpose. So, Sisi Gwatizo. Colleagues from the law school, in all your numbers, both academic members of staff, and most importantly, members of the professional and administrative staff who are here. This is 5 p.m. This is very important that you are here. I really appreciate it. Colleagues from the university, Central Human Resources, I can see a broad scope of colleagues that are very supportive. John Dean from the Water Research Commission, thank you for braving the rain and the traffic. I see Dr. Bruce from the Northwest University. Of course, my friend, a family friend, a comrade in the struggle, Dr. Makanata Makonese, who gladly agreed to come and give the vote of thanks. We struggled a bit because there's so much of history between us professionally and personally in terms of the family. Advocate Tere Mafukidze, just walking in. Welcome, sir, and thank you. Senior Counsel, Advocate Isaac Mnyuk, walking up. Maka, you can come and sit here. There are seats reserved for you here. So the queen of the house, Naishi, how are you? I'm sorry you are late, but it's okay, right? Good, sweet. And Tawana, the older daughter, Tawana Nyasha Murombo, the man who is in glass spectacles too early, Makanaka Murombo, is the firstborn. He's studying his first year here and BSc construction studies. So this is 3/4 of the family. The other quarter is still on the way. That being said, I was promoted in 2019 to the position of a professor in the School of Law. But my inaugural is only happening this year for various reasons. Part of which, obviously, Prof has already indicated, the COVID. I didn't feel that a performance would be a performance without the presence of human beings. I love seeing people. I love speaking to an audience. And the online platform did not provide the ideal space for me to profess what I profess. Therefore, forgive me for delaying this this time. I've already been in Senate. I've said here on numerous occasions. So I know what it is like to be a professor at Wits in theory and in practice. Becoming a professor, because the brief that I got was to speak about myself and my journey. But at the same time, I was supposed to speak to a paper. So I mean, the quandary that I need to speak to something that a 6-year-old should understand and continue the discourse and the conversation with me at home, but also something that Professor Jody sitting there will find entertaining, and also something that Wanda sitting there will find entertaining so that they do not go to bed, which is quite a very serious challenge, particularly when you are used to the etiquette and the protocols of the legal profession, where there is value in complication and the sophistry of language. Then you try to come down to the lowest common denominator. So if you find that there are no references or citations of sections and judges or Latin, it is because I want my daughter to understand what I'm saying. Because if we are going to be conserving water resources, it is for the future generations. And I think of all of us in this building, God willing, he is probably will be the last person to die. We'll all be old before here. She'll be the oldest person when we have all departed this planet. The topic of my talk is transforming water resource governance in South Africa using an untransformed law, the courts and the National Water Act of 1998. But before I go to the topic, and without obviously wasting a lot of time, I want to speak briefly about what is it to become a professor at Wits. I think most of you know what a professor is. I'm more interested. I want to clear my heart and my conscience by first speaking to the process of becoming a professor. Then we can go into the substantive matters that I have to engage with today. So to become a professor at Wits is a very tough challenge. It is very difficult. The journey is very long. You have to climb different levels of stairs with different hurdles and different rewards as well. But I must say that increasingly it is becoming very difficult to become a full professor, particularly in the Faculty of Commerce, Law and Management, and especially in the School of Law. And this is for all races. Of course, if you want to disaggregate that, there are some differences in terms of the impact of reforms and improvement as things change, as standards change, as expectations change. So when I joined Wits, it was very tough to become a professor then. Now it's tougher. When I say it was very tough to become a professor in 2006, or even before that, let me go back a while. In 1998, it was so difficult to become a professor at Wits in the School of Law because you simply required an LLB degree and maybe one textbook. It was so complicated, it was so tough, the standards were so high, and the quality of legal education was very exceptional compared to today. But you could very well become a professor with your LLB degree and maybe 1 or 2 textbooks, and maybe perchance 10 articles in the same journal edited by your erstwhile classmates. It was very rigorous, the process, I must say. Very few made it. During my time, you need a PhD. You need to have supervised doctoral students. At my time, it was at least 1 to completion. You need a record of publications of research, which is evidence of your of what you profess, as Professor Jason Cohen just said. And sorry, I want to acknowledge my deputy dean, my acting dean, Professor Jason Cohen, my head of school, Professor Schlema, and Professor Ian Jandro. Sorry, I forgot you. I got excited. I got excited when my family walked in. As we say in our African culture, family comes first. So momentarily I forgot you, but pardon me for that. So during my time, you were expected to have a PhD degree. You were expected to have supervised a doctoral student, at least 1 to completion. By now, I think it's 2 to completion. And you needed a good track record of research publications in accredited journals. These are the platforms where we publish our research, and there are specific lists of lists of journals where you should publish your research. So when I applied for promotion, I had not supervised any PhD student, naturally because I got my PhD in 2016, and even if I had 1 student in 2017, when I thought. Not when I thought, when in reality, I met the criteria, then I would not have been able to be promoted. However, this is the challenge in this institution. And the rigor is important because it also applies to what we do in class. But sometimes it is overextended. So I had to make my case to just cut this very long story short. I ended up having to justify why I did not have a PhD student who I supervised to graduation, because I had over 50 master's students who had graduated to completion. And it was a rarity to have PhDs, people holding PhDs in the legal discipline. Lawyers do not thrive on limitless research in the libraries and writing of long theses. They thrive on winning cases. It's a professional school. So things have changed a bit, but I think it remains quite challenging to achieve as a professor. Many of my colleagues have not finished the race. So while I'm celebrating, it's a bit of a paradox that you celebrate coming to the finishing line alone. You're number 1, but there's no number 2, but you remain in the race. And I do not blame them. This is the institutional environment more than the personal effort of some of my colleagues who have decided to leave the university altogether, or to try to find other places where their scholarship and their erudition is appreciated more and acknowledged faster. And so this lecture, I did get it to my family and to those colleagues. I saw Dr. Sa, I don't know where he's sitting. Dr. Sanles Banda there. Thank you, Doc. Professor Tsepo Mazingos, Dr. Diani, Professor Diani Muhango, Professor Mtendoweka Muhango. Those were my colleagues, my contemporaries when we joined VETS. And yeah, without them, nothing would have really been achieved in terms of me being here today and professing environmental law. Now, what I'm doing here, I'm summarizing research and scholarship that I've done over many years. Obviously, there are those who have researched over more years than me. I'm sure Professor Clarin has been in the trenches for far much longer than me. But I've also been in the trenches. So, as Dr. Sanles Banda would say, transformative constitutionalism is a complex concept. When South Africa turned the page in 1996 and had a new constitution, there was heightened expectation and anticipation that there was going to be change in the livelihoods of people, particularly the vulnerable and disadvantaged communities. So the Bill of Rights presented one big opportunity for the country to try to reverse the impacts or the effects of apartheid, of marginalization, of discrimination. And part of the Bill of Rights, you will find there, there's a section 24, which speaks to the right that we all have as citizens, or as persons rather, to an environment that is not harmful to health and well-being. That right is foundational, or is the basis of how we regulate, how we manage natural resources in South Africa. It is the anchor around which we have constructed a very sophisticated, a very complex system of environmental governance and regulation. Part of this broader framework, which I would refer to as the natural resource governance framework, is what we call water law and governance. I'm using water law here as just really an illustration. What I want to demonstrate and what I want to be able to share with you by the end of our engagement here is the fact that despite the transformative nature ascribed, I think, the ascribed transformative nature of the Constitution and the rights in the Constitution, and more specifically, the transformative nature of the environmental rights in the Constitution and the environmental and natural resource governance laws that were expounded by that particular provision. In 2022, when we look back, there is very little change in the livelihoods of the vulnerable and the disadvantaged in terms of how they access natural resources and how they are able to benefit from the exploitation of natural resources. It seems that the more things appear to be changing, the more they stay the same. So before 1998, the water laws in South Africa were governed by a piece of law that was made in 1956. It was called the Water Act. Before it, there was a 1912 Act. Under that ancient regime, which is still alive despite being ancient, it was possible to privately own water as a private resource, private property, depending on whether it was flowing through your property or whether it was in a public stream. So there was a regime where it was possible to own water privately. This is despite what we have all heard and have all known, that water is life. How then can it be that someone can own a resource that we equate to life? How can someone own water when water is life? That was the contradiction in the law before 1998. When the National Water Act was then made or enacted, there was an effort before this act became a law. There was a white paper, there were consultations, extensive consultations to try to craft a legal regime that was founded on the values in the Constitution and the rights in the Constitution. And that was founded on the aspirations of all the people who reside in this country. So this law was not made by mistake. And one would assume that the provisions in this particular piece of law, given the effort that went into making it, cannot be subscribed to oversight or to mistake. Therefore, it is legitimate for someone to make the argument that whatever provisions we have in most of the post-1996 environmental laws or natural resource laws were intentional, deliberate. Because the legislative process is a long process. You have a white paper, you have a bill, it is debated. The parliament is a whole team of lawyers, they comb through the bills, they raise any red flags on the constitutionality of any proposed law. The law is debated by politicians until there's some consensus and an act is made and the president then assents to it. And at some point it becomes effective or it commences. So my starting premise is that there is no mistake. There was no mistake in the making of the National Water Act. But what we then find in this piece of legislation is that it has done not much to change the rules and the principles that govern who can access water and for what purposes. Its attempt to change the pre-1990 situation has made some progress, but not the progress that one would expect when one looks at its objects in section 2, when one looks at the regime and the scheme that is designed in the law itself. So the reality is that we have a country that is water scarce. This is a public resource, which is life, but it is really, really not enough for all of us. Not only in South Africa, but in Africa and globally. So you would see that in my first slide, I gave you the background of the ocean there. You would imagine that with all that water, we shouldn't be struggling to share water resources equitably and be able to all have access. But what I find when I look at the National Water Act, in terms of its transformative force, in terms of its effect or impact, in terms of changing the rights of access to water and the entitlements, one finds that the state was promised powers and given powers that it is unable to effectively exercise, to implement and to execute what we would call redistributive justice, by ensuring that those who predominantly owned water resources get to offload some of their rights to water, so that those who were systematically excluded during apartheid and before 1996 can also apply for the right to use water and get water use entitlements. What you find in this piece of law is that the state is made a trustee, or rather a steward of water resources, because private ownership was abolished. So the state, as a trustee of ourselves, the citizens, is now the custodian of all the water in South Africa. As the custodian of all the water, the state is mandated and given legal powers in terms of this law to consider applications by those who want to use water for specified purposes, and then to give them licenses to use certain amounts of water for particular purposes. Of course, there are exceptions as to whether or not you need to apply for a license to use water. So when you go to section 4 of the National Water Act, read together with schedule 2, domestic water uses, or I can't escape this Latin, de minimis uses, day-to-day uses, watering your kettle, watering your backyard garden, watering a small patch of land. You can do that without applying for a water use license. The state has very little control over that, because that is the life part of water, which is indispensable if someone is going to live a life that is livable and in line with the standards and the values in the Constitution. But beyond that, if you want to use water for commercial purposes, which is an intricate concept, because how do you distinguish a medium-scale farmer and a small-scale farmer and a large-scale commercial farmer in terms of their needs to access water resources? That is the big question of the day. If you look at the small-scale farmer, some of the uses to which they put their water without the need to obtain a water use license in terms of the section 4 and the day-to-day uses, there's a very thin line between small-scale use and domestic use, particularly as people now try to make the best and the most use of the land that they have to eke out a living. So we have a challenge that there are so many people who are using water without water use licenses, and their uses could potentially constitute licensable water uses. But not only that, we still have the large commercial scale water users, commercial farmers, still retaining the rights that they had prior to 1996. But how come, if the state was able to make a new law to change the rights that one may hold or be entitled to in terms of using water, how come we still have the large commercial farmers holding the majority of our water in terms of water use entitlement? That is the rub of my presentation. So In its effort to transform the water governance regime and framework, the National Water Act could not be implemented overnight. And some transitional provisions were included. These transitional provisions, these are the provisions that were put in the law so that there's going to be continuity. You know, you don't want to disrupt the situation too much so that you actually lead to unsustainable outcomes. The transitional provisions provide that those who were entitled to use water for 2 years before the National Water Act came into force are entitled to continue exercising those rights until their rights have been converted into new water use licenses under the new act, or until they've surrendered their water use entitlements. Maybe they do not need that amount of water anymore. That is section 32 and 33 of the National Water Act. But even before we get to section 33, there is section 25, which allows holders of existing lawful water uses, the ones that I'm talking about who were entitled to use water 2 years prior to the National Water Act coming into force. Section 25 of this law allows them to transfer their water use entitlements for use on another piece of their own land, or to transfer temporarily the use of their water use entitlement on another piece of land owned by another person. That is at least according to what the courts have ruled. But when one reads section 25, subsection 1 and 2, the language that is used there is very imprecise and very inexact for lawyers, if the legislation was drafted by lawyers. And mind you, this was the time when quality was very high. Legal profession, legal drafting was exceptional. To the extent that up to now, the High Court in Gauteng province, 3 judges ruled that the provision is ambiguous. It is capable of 2 interpretations or 2 meanings. It could mean that you can only transfer your water use entitlements that are existing now, that you hold, to use them on another of your pieces of land. Or the second meaning, you could transfer water use entitlements that you hold to someone else to use on their land, a third party. What has been happening, or what had been happening up to 2017 was that under the auspices of section 25, mostly white commercial farmers, when they had no use of their water use entitlements, or when they had excess water, or when they sold a piece of land, or if a piece of land was acquired for redistribution, they would take part of their water use entitlements and using that section, which was meant to enable a transition and to at least enable multiple use of water entitlements on different pieces of land, they would take those entitlements in whole or in part and sell them to another farmer. The prices that I'm talking about here are exponential. So when I'm looking at the cases that I want to review, not in detail, so do not be perturbed. I'm not going to look at the case in detail. In one case, in the case of Luther and others versus the Minister of Water and Sanitation, the owner of a farm there sold the right to use water on 30 hectares of land for 1.9 million rands. And obviously there was an agreement or contracts concluded in terms of section 25 subsection 2 for the surrender of the water rights in support of an application by the third parties or the buyers of the rights, because they then have to apply for a water license, right, to the minister or the DG. When you go to the weed matter, there was a trust there. Of course, most of these landowners or commercial farming enterprises have now really been constituted into legal entities. They are trusts, they are companies. But that is a fiction. as Chamika will tell you, it still remains. You can tell the rest of a trust, you can tell the rest of a company. So in the weed matter, there was a trust. They surrendered their entitlement to use water on, to use 888,000 cubic meters of water per year for an amount of 5.9 million rands to a third party. Then in the second matter, in the weed, they transferred another 2.3 million cubic meters of water, entitlement to use water, in exchange for a price of 15 million rands from the third party, who is another commercial farmer. And as the judge, the justice who descended, Justice Makoka in the Supreme Court of Appeal, who disagreed with the majority of the judges that ruled that this section was legitimate, these transactions were legitimate and lawful as private commercial arrangements or contracts sanctioned by legislation. He pointed out that it was shocking that you could pay 114 rands to apply for a water use license and then sell the entitlements procured as a result of that process for 15 million rands or 2 million rands. But not only that, and this is where it gets quite disheartening. How many upcoming Black or historically disadvantaged farmers can afford to use 15 million rands to pay for water use entitlements? How many upcoming emerging farmers from historically disadvantaged individuals can afford even 1.9 million to buy the right to use water or the entitlement to use water? And mind you, in the background, there is a land redistribution process that is going on. Part and parcel of that process is that if you get land without water, it is unproductive, it is completely useless. But then, that's where things become complex. You get land, some of it does not have water, and you want to get water use authorization to use the land. In some areas, what we call catchment areas, where the rivers have been divided into their management agencies that manage water in particular areas, the water has been allocated since 1862 to the extent that there's no more water to give new allocations. And the only way, if you want to get a water use right or water use license, is for someone to surrender the entitlements that they hold from the previous legal framework or legal regime, what we call the existing law for water uses. So if you read section 25, the one that allows holders of existing law for water uses to transfer and trade water rights amongst themselves, de facto, because they are the only ones who can afford these amounts of money. And then you read that together with the transitional provisions that says very little about whether or not the government can actually force those holders of existing or historical water rights to surrender them and to reapply for new water licenses. You get the picture quite quickly as to why I'm making the argument that this particular law lacks the transformative force that it has been hyped to have. It is not a historical piece of law. At a technical legal level, when you read it, for us, the bookworms who loved and love reading the law, it sounds very nice, very eloquent and very erudite. But when you are looking at the situation of an emerging farmer, of a Black African who is trying to break into the commercial agriculture sector, and the snapshot of what I've painted in terms of how to navigate this piece of law, then you understand why this piece of law cannot constitute what Dr. Sibanda, what Carl Clay, what Professor Marius Peters define as transformative constitutionalism in relation to section 24 and section 27, the right of access to sufficient water. So this is the challenge that we have. But it is a bigger challenge because the custodians of the law, the courts who are supposed to interpret or to explain the law to us when there is confusion or ambiguity or multiple meanings. They've come to this conclusion that indeed the national water law as it exists right now allows the holders of existing lawful water uses to trade those rights. It allows them to enter into private contract agreements for whatever amount negotiated between or amongst them in exchange for the transfer of those entitlements. In another case, the Rama case, I was quite shocked at the extent to which the court relied on the common law principles of contract law to cement and to confirm the rights that the parties had created in terms of these contracts, where they were essentially contracting to ring-fence a public resource beyond the reach of the regulators or beyond the reach of the state as the trustee in terms of Section 3 of the National Water Act. So what one sees when you look at some of these judgments is the continuity of the dominance of some of these common law principles, contract, the sanctity of contracts. Once a contract has been concluded, you can't touch it. You must respect it because parties acting as free agents have agreed and they must be bound. Even if they are making promises and undertakings in relation to a resource that is now a public resource, that is life. A resource that is indispensable if you are going to be promoting sustainable agriculture and promoting sustainable livelihoods. So that is the challenge. But when you look at bullet number 4 there, the South African Association of Water Users Association was also even arguing that Section 25 indeed allowed its members to trade in water use entitlements. These associations are strong, powerful institutions. They control the information and the data on how much water is where, who is holding what water, what are they using it for. They are associations mostly of commercial farmers. They've been in control of water resources for many decades. In some cases, they have better information and knowledge than the Department of Water and Sanitation in terms of where is water, in what quantities, and what is it being used for. And here, they were supporting the interpretation or the application of this law. That is, in my view, retrogressive and untransformative in its impact on those who are seeking to break the cycle of marginalization and exclusion from accessing natural resources, particularly emerging African commercial farmers. So that is really the nub of my lecture here. And like I indicated before, I'm using the example of the water laws or the National Water Act. The same analysis can be applied when you are dealing with other natural resources. I'm sure most of you with the legal background, or even with the political, social, political background, understand the current contestation going on regarding land acquisition and expropriation of land, and whether or not the Constitution is clear on whether land can be compulsorily acquired with or without compensation. To the extent that we have had to make a new law to define simple literal English that is in the Constitution. That is part of the resources. And you cannot separate land resources from water resources. You can't separate forest resources and non-forest timber produce from natural resources. The same applies to wildlife. You know, how you access wildlife, who can start a conservancy, what are the processes that you have to navigate in order to access and to enjoy the benefits of some of these natural resources. So this is the unfortunate reality in South Africa. It's a microcosm of the reality in Africa, most of Africa, where there was colonization and dispossession and marginalization of the indigenous communities from accessing and using natural resources. What does this mean for transformation? As I have already indicated, this means that we have laws that purport to be founded on advanced constitutional theories and principles that are aimed at promoting transformation and change, including the Constitution itself. Yet in practice and in reality, most of these laws serve to entrench, protect, and galvanize vested rights, or the rights that people had prior to 1996. With that situation, or in that context, it remains a dream in my submission to expect that these type of laws are going to enable us to achieve redistributive justice and to deal with the historically unjust acquisitions that have characterized access to resources in South Africa and most of Africa. Therefore, if we are going to really enable law to play its role as a social instrument of change, to change the fortunes of those who can only rely on the state to change their livelihoods, it is important that we change these laws. And the legal reform process that I'm advocating for here is not technicalism, using more words, more qualifiers. We need explicit language that is very clear to say that, for example, in the case of the National Water Act that I'm talking about here, if you were entitled to use water 2 years before 1998, and up to now you have not applied for a water use license under the new regime, your old rights are going to be extinguished if you do not apply for a license in the next 1 year or 2 years. That is perfectly legitimate in terms of the provisions of the National Water Act. There is what is called compulsory licensing, Section 43, which has not been effectively used by the state or by the Department of Water and Sanitation for various reasons. Because remember, when these laws were made, they were not just made by the progressives. They were those with vested interests. These associations and institutions that I'm making reference to were central to the discussions, the negotiations of what provisions to put in these laws. So, by design, if the state is going to attempt compulsory licensing, first it must undertake what is called a verification exercise to verify for every registered water user, what were they using 2 years before 1998? Is that possible? This process includes using Google Maps, satellite imagery, to see what Murombo was doing in 1997 on his farm, how much land was under cultivation. And the data is not what it could be. It's not usable practically. So the verification process is very slow. It is happening, but it is very slow. It is going to take many, many decades for the government to be able to verify and validate the existing law for water uses, which is a precondition for the government to be able to implement or to enforce compulsory licensing. Because then you don't know who owns the water, how much water, what were they using the water for 2 years prior to 1998, and whether they are still, in fact, exercising those rights and using all the amount of water that is being allocated to them. So this legal situation that we are in demonstrates that South Africa, like many post-colonial states, is saddled with laws that are pretentious in terms of their transformative intentions and transformative provisions, that are pretentious in terms of their effect and their impact. And what we see is continuity of the marginalization, the discrimination of those who could not access natural resources, despite them being the owners of these resources. Possible reforms, my contribution. I think I'm making an unanswerable argument that the water laws and the natural resource laws of this country and similarly situated countries who have copied the law, because it is very nice, it is internationally acclaimed, just like the Constitution. Many countries have copied it, those countries that have copied this particular piece of law remain colonized in relation to the control of resources. And many people who went for liberation struggles will tell you that they were always fighting for the land. The land is a symbolism for natural resources. It's not just the land. They were not just fighting for the land. They were fighting for natural resources and for control of those natural resources. That control is in theory been given to the state through trusteeship, custodianship, and the state is crippled through intricate provisions that disable it from exercising stewardship or the right of custodianship, as I have already made reference to. Our courts have regrettably taken a route which entrenches this status quo or this reality. And there is a constitutional court judgment pending. But I argue that whatever the outcome, whether it is for the historically disadvantaged individuals or whether it is for the historically advantaged individuals, it still remains a bleak picture in terms of the role of law in redistributing natural resources. Robust and even drastic reforms are necessary. However, such reforms must not be blind redistribution. There are many examples that we could give, we could discuss the whole night of resource redistribution that have gone wrong, have led to unsustainability and unsustainable use of natural resources. So you will find that there are principles that require us to use our natural resources sustainably and beneficially. I end. But I end the actual, inaugural lecture. But my journey, like I've indicated, I did give you a piece of my journey in the law school and at WITS. My journey began at that school in the background there. It's called Jarawaza Primary School in the rural areas in Zimbabwe, in Bikita. So that's where I grew up. We used to head cattle in those mountains. And from there, I went to Sakuba High School in Mutare with the people. Sakuba is like Soweto in Mutare. It was a day school. All the people that you see in that particular picture are either physicists, doctors, engineers, and of course, there's a lawyer without a tie there. I'm showing you these pictures because for me to become a full professor, this is where it started. If you have read my writings and appreciate the art of writing and appreciate my own approach to writing, it didn't start at VETS. It didn't happen at UCT where I did my master's. It didn't happen in the United States where the English is modified. It happened partly at the University of Zimbabwe. But in that picture there, what you are seeing is me when I was probably at the most efficient of my brain power and thinking and writing critically. To the extent that I was reading there, I think that is D. Thompson, Europe since Napoleon. I wrote an essay and my teacher said, this is university stuff, Dr. Murombo. And I'm glad that I have fulfilled that prophecy by Mr. Raymond Damba in Sakuba High School. And being a professor, one of the things that have enabled me to engage with this kind of conversation or discussion that I've done is that I am not theoretical. That was me in 2003. We were addressing chiefs and traditional leaders in relation to the use of natural resources. So I teach what I practice, and I practice what I teach. And in the afternoon, the colleagues that were setting up the system here were saying, we have water problems. What are the professors doing? I said, we have different types of professors. There are professors like me who preach what they teach and practice it and teach what has been informed by practice. And there are those who teach what they read in books. That is my mother in the Mandela Institute office, obviously with my best friend there. And that is my mother and her sisters. Some of you have asked me, what if I do go overtime? A lot of my colleagues have asked me, how do you know so many things? Things that have nothing to do with law. You just seem to know some things. those four ladies there in the communities that they inhabit are the ones that enabled me and gave me the skills and the common sense to be able to know so many things. It's called wisdom. You don't get it from PhDs, you don't get it from sitting in lecture theaters. You get it from living in a community. And these are the people that made me who I am. Obviously, these are the guys behind the screen there, my wife and my three children. And these people have supported me through thick and thin. I love reading, I love what I do, to the extent that sometimes I forget them. And the 6-year-old comes to my study and says, when are you going to stop studying and reading? Are you not rich yet? So I tried to explain to her that I was rich a long time ago, but it's not about being rich. It's about keeping young and keeping your brain cells active. Family friends that have kept us going, that's Mr. and Mrs. Muka. He's a maths teacher at Sayed. They've supported me through thick and thin in my academic career. That's my wife there and Professor Diani Muhango. Obviously, the usual culprits. That's a lawyer who employed me when I was in second year and our university had been closed. He groomed me and mentored me. His name is Mishek Mgada. He's now a ZANU-PF member of parliament in South Mtare. These comrades here are the ones that enable me to bounce off ideas and to make crazy arguments without judging me, but at the same time telling me to go to hell when it's necessary. Some of them are here, some of them are not here. That's legal practitioner Isaac Muyugi sitting there, and Mutomba, and Comrade Vava, who is the Chief Executive Officer of Christ Coalition in Zimbabwe. And again, the same colleagues there. And these are colleagues from the Zimbabwe Environmental Law Association that is defined and enabled us, myself and my colleagues, to define environmental law scholarship, research, and community engagement. I do not have time to go through a lot of this particular slide, but I think my colleague is going to go through that. These are my students in David Webster. I spent 13 years as a ward in David Webster, because I also love students. This is why I started my protocols by acknowledging my children and the students, because I think they are more important than anyone who is sitting in this tall building. Without the students, we wouldn't be here. So I love the students, and I spend sleepless nights to ensure that they get the edge. And that is the evidence when they are getting the edge. Some of those graduates are here, they are lecturers in various schools in Johannesburg. I can see Mr. Maflela there is a lecturer at the University of Johannesburg. Former students at the University of Zimbabwe. Now, one of them is the dean of the Midland State University. Some of them are in the law side of Zimbabwe. Communities again, me with communities, my colleagues, some of them are judges in the High Court in Zimbabwe. Advocate Mr. Bere, Otosaki of the Ford Foundation. These are the people that give me energy and inspire me. And we often say we are inspired to inspire. They inspire me, I inspire them as well. And there we are engaging with communities, engaging with international organizations. I have so many pictures, I will not be able to go through them. I was at Harvard Law School explaining why I think sometimes law is anti-development. That was in China. We were discussing sustainable development. It's easy to see me. Just look for the lone black face. Very easily identifiable. I've worked with international organizations, and I appreciate the platforms that have been presented by some of these organizations. That was at UNEP. We're shaping a particular international legal regime and engaging with colleagues and obviously teaching, practicing what I teach. That was inside a nuclear power plant, and I teach nuclear law, not in theory, but what I've seen and experienced. I also thank the the team that I worked with in the Mandela Institute, they were very important because I applied for this promotion while I was still in the Mandela Institute, which was a management position. And the criteria for promotion, like I indicated before, paid very little regard to my efforts in the Mandela Institute. It's part of the motivation that I had to make. Regrettably, I had to leave it before a second term because it became quite disruptive to continue being excellent in that institute. The late Professor Bob Scholes there, Baron Erasmus Global Change Institute, colleagues that have supported me within VETS in terms of the research that we do in. This inaugural lecture is limited to 1 hour, which I have used all of it. And I'm sure, at least for today, because this only happens once, I will be entitled to a few minutes to enable my family friend, to give a vote of thanks. And unfortunately, you are not able to ask questions. Professor Kora said to me, this is the only time when you can say whatever you want to say, and no one is going to ask a question. And I said to her, don't you think that is a dangerous thing to do to a lawyer? Because legal practitioners are used to motivating and making arguments in anticipation of rejoinders and responses. But that being said, I'm available. Yeah, you can contact me to engage me on some of these the issues and the arguments that I've raised. You can engage further with them in my work that I've done, both academically, the accredited publications, in peer-reviewed journals, or in the very nice judgments of the Water Tribunal that are not peer-reviewed or accredited, but possibly more legally binding and valid than some of the articles that I have published. I rest my case. Thank you.
Murombo was 2 years behind me at the University of Zimbabwe, and that was a long time ago. We both had an interest in environmental law, which at that time was a very new subject that was that had been introduced at the University of Zimbabwe. And therefore, only a few of the students at the university then had an interest in environmental law, but the two of us were amongst those few who had that interest. I think for him and others, their interest in environmental law was further stopped when there was a visit paid to the university by 2 environmental law enthusiasts at that time. One was Professor Owen Lynch from the Center for Environmental Law in the United States, and Dr. Rubmeleza Nchala from the Lawyers Environmental Action Team in Tanzania at the time. And during this visit, Professor Owen Lynch gave a lecture about a career as a public interest environmental lawyer, which then was not attractive to many law students who were eyeing lucrative corporate practice and private practice as careers. But suffice it to say, a few years later, after we left university, Professor Murombo, myself, and 8 other recent graduates from the University of Zimbabwe formed the Zimbabwe Environmental Law Association, which was the first and still currently the only public interest environmental law organization in Zimbabwe. Following the formation of ZELA, or the Zimbabwe Environmental Law Association, for many years, we all worked in different organizations and institutions, as there were no funds for us to run the organization on a full-time basis. So we were coming in mainly in the evenings after we had knocked off from our day jobs in order for us to do the work associated with the Zimbabwe Environmental Law Association. But despite the limited resources that were at our disposal at that time, our passion for environmental law, for the environment, for helping communities managed to spare us to continue to work to ensure that the organization would grow into an organization that could provide the assistance that communities needed or required in terms of access to resources and their environmental rights. We traversed the country and Africa as a whole as we raised environmental rights awareness, provided environmental rights education, and built community capacity in the most remote parts of Zimbabwe in Africa. At the national level, we worked with indigenous or local communities in identifying environmental rights violations and seeking redress for such violations in magistrates courts in rural areas, but also even in the High Court of Zimbabwe. Community work at that time was, and I think even still remains challenging, as public interest lawyers were required to engage with authorities at various levels in order to access local communities. But as young, impressionable lawyers at that time, we've often found this political access control inhibiting, and we disdainfully viewed it as a violation of our rights and the community's constitutional rights as well, the communities that we're working with. Therefore, as a result, we often went about our public interest work without seeking the politically imposed but legally unnecessary or unrequired clearance. That was basically a political requirement as opposed to a legal requirement for us to be able to work with and access communities. But this was until one day Zela was ordered by the police and other senior government officials to disband an international conference on Marange diamonds in the eastern town of Mutare. And this was a conference where we had brought in a lot of lawyers from around the world, with many of them coming from different African countries. And before the conference could even start, we were ordered to disband and for everyone to go back to their homes, for everyone who had come in from different countries to fly back to their countries, because we had not sought the required clearance in order for us to have that meeting. And of course, Professor Murombo, being Professor Murombo, openly challenged the police as well as the government officials who had come to disperse the conference. And decades later, even today, when we are trying to seek government assistance in many of the Zela activities, there's one government official who doesn't hide his dislike of Zela, and of Professor Murombo in particular, because of that incident so many years ago. Professor Murombo has remained a committed member of the Zimbabwe Environmental Law Association, where he currently sits as the board chairperson. And when he gives advice to the young lawyers who currently run the programs and work of Zela, he at least has got a toned down approach, if I may say, on how as public interest lawyers we should work with government officials. He insists that we should engage with government officials where necessary, only to allow us to give the assistance that we should be giving to communities. Because otherwise, we take the approach that we are not going to be seeking the clearance or the intervention of government when they should, we will never be allowed to work with the communities. And at the end of the day, it is the communities that we are supposed to be assisting that will suffer. This interest in water rights and law, started when we worked with a community called Dora Pindo, again in Mutare, which is downstream of the city of Mutare, whose source of water was polluted by the Sakuba River. Coincidentally, I'm sure I saw in some of his pictures, this river was named after the high school that Professor Murombo attended. The river in question was being polluted by industrial water and sewer water, and as well as effluent coming from the city of Mutare. And today, as he delivered this inaugural lecture, I realized that his interest in this area of human rights and resource governance law is not diminished, but has instead intensified. In his lecture, he has illustrated that in the current discourse, the issue of water as a public resource remains contentious, although post-colonial governments have sought to remove water from private ownership in the public interest. While much has been done from a policy and law reform perspective, the practical impact of the water law reforms has been limited by what he called compromise or transitional clauses. Most of these transitional provisions have no sunset clauses, thereby perpetuating the old resource governance regimes and further marginalizing and excluding previously disadvantaged communities. Mining and other industrial activities continue to pollute community water sources with serious implications for the lives and livelihoods of many communities. This regrettable legal reality extends to other resources like land, wildlife, and minerals as well. Beyond water resources, Professor Murombo's scholarship is ably engaged with the regulation of some of these resources, especially the extractive industry.
His passion being always to seek legal reforms and lawmaking that resonates with Africa's social, economic, cultural context to the benefit of vulnerable groups and resource-rich countries. Through our work together as public interest environmental lawyers and academics, we have not only built careers and institutions, but friendships and bonds that have brought our families together. My children do not hesitate to contact Uncle Tumai, they call him, whenever they need career and academic advice. And when Professor Murombo left to study for his second master's degree at Percy University, the University of Zimbabwe, I was there to support Mrs. Murombo and Makanaka, who was at that time just a toddler. And that is, if what I did could be called support at all, because I had to uproot them from their home in the leafy suburb of Avondale in Harare. Those who know Avondale will attest that it is one of the very beautiful residential areas in Harare. But I had to uplift them from Avondale and drive them to their rural village in Bikita and hand them over to Gogo Murombo, my mother, in order for them to, wait it out whilst Professor Murombo was pursuing his studies in the United States. I'm however sure that Mrs. Murombo will agree and confirm that this episode in their lives was all worth it as we celebrate Professor Murombo's academic achievements today. Professor Murombo has been a constant support in my own academic life and that of many of my contemporaries. He always encourages me, and I'm sure many of his students as well, as he has indicated, who are working in different capacities, including the civil sector, in public interest law, and just to ensure that citizens in different capacities in different areas are able to access justice. Just like many others from our generation who were born during colonialism in Zimbabwe, and especially were born at the peak of the struggle for liberation, we do value education because it was not difficult, it was not easy for people at that point in time in the history of our country to access education. We're the first generation to benefit from the government policy of free universal primary education soon after independence, the independence of Zimbabwe. We therefore, and I'm sure him, Professor Murombo as well, he has always cherished the opportunity to learn and enable others to learn. It has encouraged me and others through this erudition path. And as we come to the end of our proceedings today, I would like to sincerely thank him for this inaugural lecture, which was a scholarly illustration of his passion for human rights and social justice in the water sector, a passion that I'm sure we'll continue to see as we follow his teaching and research work. And to Mrs. Murombo and the children, I once again would like to say thank you for being the constant cheerleaders for Professor Murombo in his academic life. I'm sure the people from the faculty and the university leadership will be thanked by someone else because I'm not a member of faculty. And therefore my focus, I think, in this on our path as colleagues, as family friends, and that is why I focus on thanking Mrs. Murombo and the children. But I think it would be amiss for me not to thank all of you who have attended this lecture in person and online for honoring my longtime colleague and friend, Professor Tumai Murombo, by being part of this significant milestone in his career and in his life. I thank you.
Thank you so much, Dr. Makonese, for your response and sharing those stories of your work together and for where your and Tumai's passion for this field comes from. I'm sure all of us here and online agree this was an absolutely wonderful way to spend an evening together. Tumai, we count ourselves lucky to have you as a professor in the law school and in this faculty. I'd ask you all to give Professor Murombo another round. Friends, at this time, let me invite you to join us outside for some refreshments in the foyer, a chance to catch up with Tumai, have a chat and catch up with each other, and we hope to see you again soon for another celebration. I'll ask you all to stand up and we'll let the academic procession lead us out.